Hello, everyone. This is Tom Zuccaro. Welcome back to SEC Roundup. With me is Nick Morgan, as always, the founder and president of ICAN. Nick, how are you today?
Hey, Tom, doing well, thanks.
We are delighted to have as our guest today Michelle Reed, a noted cybersecurity lawyer. Michelle is a partner at Paul Hastings, a firm Nick and I know well. But she's a partner at Paul Hastings and co-head of its data privacy and cybersecurity group. Michelle, welcome to SEC Roundup.
Thanks. Delighted to be here.
Delighted to have you. So I guess I kind of gave away the content with Michelle's introduction, but we are going to talk about the SEC and cybersecurity, and in particular, uh, some recent events from the commission, both in the SolarWinds case that's pending against SolarWinds in the Southern District of New York, and then some recent enforcement activity. And at that, I'll hand it off to you, Nick, and maybe you can bring us up to speed on what's happening.
Yeah, so these settlements that Michelle's going to talk about from a couple of weeks ago did not happen in a vacuum. The topic of SEC and cybersecurity is a continuing one. And Tom, you may recall episode 4 of SEC Roundup. We touched on this very topic 3 years ago. Um,
Uh,
let's see, that would have been 2021. So around the same time that we were talking about that, some devious hackers were hacking SolarWinds and attacking them in their Orion software. A short while later, in 2023, the SEC sued SolarWinds about that hack and specifically brought fraud claims. These are the intentional type fraud claims, 10B and 17A1, alleging that certain statements and omissions by SolarWinds about the hack constituted securities fraud. Um, Pleasing to our ears, SolarWinds elected not to settle that case and filed a big motion to dismiss, which was decided in the Southern District of New York by Judge Engelmeyer in July of 2024. That ruling, largely against the SEC, was a bit of a blockbuster. It was 107 pages of the judge taking the SEC's case apart. And when the judge was done, there was not much left of the case. Although, Tom, as you say, and the decision came out in July of this year, the parties are continuing to litigate. They're in discovery. But most of the claims the SEC brought were dismissed, which is a very unusual thing to happen for an SEC complaint in federal court. Um, what were removed were most of the fraud claims and claims based on internal controls violations, all taken out. And also the chief information security officer was individually sued in that case, and many of the claims against him were also dismissed in the same opinion. So that case continues on. But in the meantime, the SEC was busy investigating the customers of SolarWinds. And that's what we're going to talk about today, the settlements with those customers. And a couple of other data points before Michelle gets into the settlements. First, we have had a separate SEC roundup on the SEC's recent public company cyber breach disclosure rule. That's not really a factor here. That was effective or became effective in December of 2023. The conduct at issue here happened before that date, so the rule not really a factor, but I expect we'll see that rule make an appearance in some action sometime soon. And the last two things I want to mention for context to these settlements is that the SEC is sort of rowing upstream, if that's the right metaphor. The Supreme Court has not been entirely receptive to the more aggressive moves the SEC has made recently. And just to touch on two from the most recent term, actually neither of which involved the SEC, but I think fairly constitute tea leaves that might impact the SEC in this area. One is the Corner Post decision, which extended the amount of time within which an aggrieved party can sue for injury under the Administrative Procedure Act So that may enlarge the pool of plaintiffs or defendants willing to challenge the SEC in this area. And second, there was a private securities action involving 10B, the McCary case that involved pure omissions. The Supreme Court gave that pure omissions case a frosty reception. Again, not directly on point here. It wasn't an SEC case, but if you're trying to figure out where the SEC will go when these cyber breach disclosure issues reach the Supreme Court, I think it's useful to take note. I think that brings us up to date.
Okay, Michelle, it's your turn to give us your wisdom. So one could look at these cases that were just brought, and one of the SEC dissents focuses on this is that these companies were victims, and yet were accused of by the SEC of disclosure violations. Give us your assessment of those cases and what types of questions are you getting from your public company clients, and what are you telling them to do with respect to their own disclosures?
It's a great question. There's four companies that were part of this enforcement, and you can bucket them in two ways. One bucket are companies that actually did make disclosures, but the SEC said that wasn't good enough. You needed to give more information. And then there was another bucket of companies that did not make disclosures, and the SEC said, well, what you said was misleading. They made disclosures that were descriptions in their 10K or their 10Q. And essentially they said, okay, you didn't make a separate 8K about this incident, but you did have statements related to cybersecurity. And because you had those statements related to cybersecurity and you were impacted by this incident, you therefore had an omission. And I think that when you look at those two sets of things, it presents a lot of scary situations for clients because this is an area of a lot of gray. It is not a situation where if X happens, it's really clear you have to have Y disclosure. When you have a cyber incident, the facts as you know them change over time. The facts as they implicate the company and the impact that they have to the company change over time. And for one company, it might be significant. For another, it might not. And when you look at the disclosures as a whole, most people have risk factors as they are now required. And those risk factors in almost any instance could be considered misleading if you don't disclose a lot of stuff. And so for a lot of my clients, there's a great concern with how do we characterize our 10K, our mandatory 10K disclosures? What do we need to say in our queue? And then on the flip side, when my clients have incidents, there's a lot of debate over not just whether to make a disclosure, but if you make a disclosure, what do you actually have to say? Because when you look at the SEC's guidance and the SEC cyber disclosure requirements that were finalized about a year ago and had been or were enforced as of about a year ago and had been finalized, I think in mid-2023, there's not a lot of detail. There's a whole lot of discretion that you would have on the way you would describe materiality in any securities case. And so it's not prescriptive. It doesn't tell you exactly what to disclose or how to disclose it. It just says if it's material, you need to disclose it. And that leaves a lot of companies floundering with how to handle the disclosures when they have an incident.
Michelle, let me ask you, in these cases, do they involve pre-cyber incident disclosures, or do they involve disclosures made after the cyber incident occurred?
Yeah, so a great question. All of the statements at issue are post-incident disclosures. But what I think is important, so there's the two with the 8K are obvious, or with this one was a 20F disclosure and one was an 8K. The two that actually made affirmative disclosures about the incident, those were clearly post-incident and had been drafted post-incident because they were addressing the problem. The two that were they allege were post-incident, likely had language that existed for some time. And so that is sort of a warning case to a lot of companies who recycle their language filing after filing on, when they have their Ks and when they have their Qs. And if you don't take a real look at it, there could be something misleading. And what's troubling here is that although all the language was post-incident that they're holding actionable, a lot of the language pre-existed. And when you look at the language itself, you could arguably see why they might not have thought this to be particularly material or not material, such that they needed to revise those risk disclosures. Because a lot of people look at their risk disclosures as speaking in the hypothetical, I think this is a big red flag for everyone. Speaking in the hypothetical, particularly in the cybersecurity realm, is very dangerous now. Particularly because most companies of almost any size have at some point in the life of their company had an incident.
There were two things I noticed about the settlements when you talk about the danger that these settlements present, Michelle. One is the penalties were pretty big. They were, for three of the settling parties, it was about $1 million. And for the fourth, it was, I think, $4 million. So these are not insignificant penalties. The other thing is that I guess sort of understood here is that these are all settlements on the basis of the settling party neither admitting nor denying the SEC's allegations, which, as we all know, means they are prohibited from telling us their side of the story. So I'm sure there is a host of mitigating factors that they would love to tell us all about as to why this was okay and why that was okay. And we'll never hear about them because the SEC prohibits them from telling the marketplace about, their version of the facts.
That's right. Well, when you look at the one that was the biggest settlement, so the $4 million penalty, the issue in that instance was they had post-incident disclosures that were in their 10K that described risks from cybersecurity events, but they used the word hypothetical, despite allegedly knowing that they had experienced 2 SolarWinds related intrusions. And so for that one, you saw the violations of 17A2, 17A3 of the Securities Act, and then 13A of the Exchange Act, and then the 12B20, 13A1, 13A, 15A. But when you really drill down at what the SEC's concern was and why you think you probably saw a $4 million penalty in that one, it's because they felt like at least I would speculate that they felt like it was misleading, that if you had 2 incidents that were directly related to a known incident, and then you're describing to your investors hypothetical problems, that they believe to be, misleading. And because they made some statements there, once you've spoken, you have some sort of duty to, not omit material facts, which they think this is material. So I think that's why you saw that particular one stand out. The other ones seem to be a little bit different. And in particular, the ones where there were actually 8Ks issued, those are the ones that sort of, if I had to say blow my mind, they blow my mind. Because when you look at the one, they were complaining that you didn't describe the type of threat actor. You didn't say that it was a sophisticated nation state threat actor, and investors would like to know that. Well, investors would in theory like to know a lot of things, but you have to look at what a reasonable investor is and whether it would influence their, particular investment, right? Their investment making decision. And when you look at that, does the actual name of the threat actor in the 8K, is that really material? And there are a lot of reasons why you don't want to name the threat actor in your disclosure. I mean, I guess that one was at 20F, but there's a lot of reasons why you don't want to name the threat actor in your disclosure. You don't want to draw a highlight to it. You don't want to, it really is not particularly material. So a lot of times you're not even exactly sure, and probably they didn't even have access to all of the information. I mean, SolarWinds was the one with access to all of the information on the threat actor, and they were doing derivative investigations associated with it. I didn't represent any of these people, so I can't speak to the specifics, but having done this a lot, you're relying on a lot of different things. And when you're making a public statement, you want to make sure that you can validate absolutely everything and that you have that. So there's lots of reasons why you might not name the actual name of the threat actor. In fact, if you look at most disclosures, most of them, even after the SEC passed its rule, do not name the threat actor. In fact, I hesitate to think of, I think there's maybe one or two that did, and that's it. So that is an unusual, I think, position to be taken. The other one that is, I think, just a little bit wild is on the last one, the 8K, and this is like the lowest settlement, so good job to this company. But they allege that the 8K failed to disclose the nature of the code that the threat actor exfiltrated and the quantity of encrypted credentials that were accessed. Now, let's think about that. That's very, very specific information. That is making an assumption that an investor cares about the nature of the code and the number of accounts, the encrypted credentials that were accessed. Again, I posit, if you look at all of the disclosures that have been made over the past year, you won't see people describing the number of administrative accounts or customer accounts, in detailed specifics. And there's a reason why, because as you go through these investigations, that number changes on the daily. And, you think it's X, then it ends up being Y, then it ends up being K, and you don't want to mislead, right? And you don't want to be questioned at the time. And so you sort of make statements that are I would say, more on a directional basis as opposed to a specific number or providing that kind of level of detail. Now, you might provide that level of detail on your website or, something where you have a more iterative response. But when you look at what's material to investors, really material to investors, the nature of the code that the threat actor exfiltrated or the quantity of the encrypted credentials accessed. I mean, I would posit no. And so you can tell that I'm a defense lawyer at this point. But it truly is an extraordinary situation, I think.
Yeah. Well, I do want to note for posterity that we're having this discussion on the eve of the presidential election, which means two things. Number one is the hackers will stop spending their time trying to hack into the presidential campaigns and go back to the regular hacking activity of public companies. And two, perhaps we will have new leadership at the SEC within 6 months or a year, and that may change the direction the commission takes. But until then, I think, Michelle, you're going to be a very busy cybersecurity lawyer.
Yeah. I suspect we'll be busy no matter what direction it takes.
Yeah. A couple of other things as you were describing the cases, Michelle. One is, unlike the SolarWinds case, no individuals, no intentional fraud claims. These are 17A2 and 3, the so-called negligent fraud claims, and Section 13, false filings claims. And the other thing that strikes me is we know SolarWinds had more than 4 customers. So there are other cases out there, and maybe one can hope there are customers who chose not to settle, and we'll see more litigation. Maybe it'll end up in front of Judge Engelmeyer in the Southern District of New York.
Well, it's an interesting point, Nick, and I'd like to add this. I don't know if you recall, but a few years ago, the SEC, in connection with the SolarWinds investigation, actually did a sweep. They sent out letters to public companies who were all guessing, but I think it's pretty clear they probably demanded of SolarWinds a customer list of customers who had downloaded the particular impacted element of the Orion software. And they sent that out and they promised immunity. And they said, if you respond to this in this very short time period, we'll give you immunity. So be sure that you respond to this. Now, mind you, one of the questions was not just about SolarWinds, but they also said, hey, if you've had any other incidents that lasted more than 24 hours, include that too. And by the way, promised no immunity for that answer. So customers responded in varying different ways. Some of them rushed to get the immunity, and then some of them didn't respond at all. I think these enforcement actions really have implications for the SEC when they send a sweep like that. When you have companies who in good faith are making disclosures about the incident, and they're believing that they've given what they needed to provide, and and they're still having to face enforcement. How many companies are going to want to voluntarily provide that information to the SEC? I would suggest not many at this point, when you see that the victims are now getting their double victim status of now having enforcement. Now, that's not to say that if you have disclosures that need to be made, you need to make them. And there's certainly SEC rules and requirements that cause you to do that. You need to make sure that you're evaluating materiality. But there's a whole lot of implication from what this enforcement action does. It may not put a CISO on the line, but it puts companies on the line who are customers of a supply chain breach. And we're going to see that all the time. You'll see a thread through, we're doing actually a report on the SEC disclosures. So you can look at that and see if you have interest in that. But when we looked at all of the disclosures that were made over the past year, there were several that were related to supply chain breaches, where someone else's breach resulted in an SEC disclosure. And these supply chain breaches are so challenging to assess disclosures and what needs to be made that it makes it an especially challenging situation. And I think the SEC is going to have a hard time getting anyone to answer a sweep like they had for the SolarWinds.
Well, Michelle, if I were a general counsel and my company was hacked, I would call you.
Aw, thanks, Tom.
And with that, terrific episode of SEC Roundup. Michelle, thanks so much for joining us. Nick, pleasure as always. And we'll see everyone back at the next SEC Roundup.
Thanks so much. Bye.